Hi everybody, it's Andy and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over how California law provides for attorney's fees in probate cases. So for those of you who don't know, a probate case basically arises when somebody has passed away. This person could have passed away, due to old age, due to an illness, or maybe they died because of an accident. Regardless of how they died, however, they are going to have left behind a bunch of stuff. So stuff could be furniture, it could be clothing, it could be a house, a car, stock, bank account, whatever. And at the same time, the stuff that they left behind could also be debt. So for example, they've left behind a mortgage on their house, they had credit card debt, maybe some of this debt is secured by something, maybe it's unsecured, etc. So they've left behind assets and debts, and the probate process, in a kind of very simplistic sort of nutshell, is basically the court process, the protocol, the structure, the procedure, I guess, by which the assets and the debts of the person are taken care of. So for example, ideally, the assets of the person will be distributed to their relatives and their friends in the manner in which this person wanted. And at the same time, the debts that the person left behind, hopefully they will get paid. All the creditors get what they're supposed to get, what they're supposed to get paid, so nobody loses any money. So that in a nutshell is what a probate case is. In the probate case, a lot of times the responsibility for filing the case, kind of interacting with the lawyers and stuff, typically that will fall to a surviving relative of the deceased person. So this surviving relative could be a spouse, it could be a child, hopefully an adult child, it could be an adult grandchild, there could be any number of immediate family members that the responsibility for shepherding, I guess, this probate case sort of falls to. Now typically what happens when I see this relative is they kind of know that this person has passed away, and they know that there's a lot of legal documents and papers and things that need to get signed, and they basically look at it all and they basically go, oh my god, I'm so overwhelmed, I have no idea what to do. And the immediate thought, unfortunately, right after that, I think a lot of times is, I need help, but I don't have $10,000 to hire a lawyer, I don't have $5,000, all I have is a couple $100 and I can barely get that together. I live paycheck to paycheck, for example. And this concern, I think, causes a great deal of stress that is completely unnecessary because of two laws in California that do not require the relative who's shepherding the whole thing, to pay up front. Now, before I go into those two laws, which I will, don't worry, I need to define basically what an ordinary fee and an extraordinary fee is. So under the probate code in California, there are two types of fees for attorneys. There's an ordinary fee and there's an extraordinary one. Now from the names, you can perhaps guess what the difference between the two of them are. So an ordinary fee is for lack of a better term, a routine case, a typical case. It's not a case that is exceptionally easy, it's not a case that's exceptionally hard, it's kind of run-of-the-mill, average, typical. So for that, it's under California Probate Code 10810, 10,810, I guess. But that code section basically says that for an ordinary fee, the attorney that does the case will get paid as a percentage of the deceased person's estate. So if you look up Probate Code 10810, it basically says that, it goes by value, I guess. It's a staggered kind of formula. So for the deceased person's estate, the estate meaning all the sum of all or the value rather of all of the property that they left behind, if you add all of that up, of the first $100,000, for example, the lawyer will get X percentage. For the next $100,000, they get a different percentage. For the next 100 on top of that, they get a different percentage, and then the 100 on top of that, they get a different percentage, and so on. So if you do the math out, I'm sure it averages out to something. But the important thing is that by law in California, ordinary fees for a probate attorney are not going to get paid up front. The relative does not need to come up with 10 grand or 5 grand or something as you would in, say, like a divorce case, for example. The attorney will get paid, as compensation for their time way at the end when the case resolves. They'll get a percentage of the estate that is being kind of passed through the probate. So that's for an ordinary fee. For an extraordinary fee, then, this is Probate Code, California Probate Code, rather, 10811. And that basically says that an extraordinary fee is for a case in which the work is there's extra work involved, there's complication, there's something unusual about the case that requires the lawyer to do a lot of work. So for example, it could be something, just kind of talking off the top of my head here, it could be something where all of a sudden a whole bunch of illegitimate children pop up, or there's all these debts over here that nobody knew about. All this stuff that basically was not expected when the case came up, and now all of a sudden requires a lot of extra work to deal with. So that's what an extraordinary fee is for. It's for unusual, kind of atypical cases where the lawyer has to do a lot of work because complications or surprises have come up. And under Probate Code 10811, 10811, the lawyer does not ask for the extraordinary fee up front either. The lawyer, after the case is done, can apply to the probate court for permission to charge X amount of extraordinary fee for all the special work or the unexpected work that the lawyer had to do. Extraordinary fees, judges can grant them, judges can't. It really all depends. But the important takeaway for both fees, extraordinary and extraordinary, is basically that the relative who's in charge of kind of shepherding the case, filing the case, hiring the lawyer, all that stuff, the relative does not need to come up with that money. By law in California, 2 laws, remember Probate Code 10810 and Probate Code 10811, by law all the fees have to get dealt with at the end, either by special permission from the judge or as a percentage of the estate that is being passed through probate. So hopefully that helps. I mean, this is kind of an unusual situation relative to, say, a divorce case where you might need to come up with 15 grand or something, or it's different than, say, a personal injury case where the lawyer just takes a percentage at the end. It's kind of like that, but the percentage is a little harder to compute, I guess. And it's also fixed by law, so it's something that the lawyer and the client really have no, they can't negotiate it or modify it or anything like that. Like, the law says what it says. So anyway, as with all my videos, hopefully that was helpful. This is something that I see a surprising amount of people kind of worry about, and it's completely unnecessary because the code sections are very clear and they say what they say. So again, hope that helped, and I will talk to you guys next time. Go ahead and leave me a comment, subscribe, all that nice stuff. And like I said, I'll talk to you guys next time. Thanks.